Hi everyone, this is Immigration Attorney John Khosravi. I want to do some quick updates and 8 quick notes about the Department of State's decision regarding the executive order of Donald Trump and the Supreme Court decision. Now, this isn't going to be an inclusive list, but it's some important notes I thought we should talk about. First of all, this doesn't affect people that already have visas. Second, even if you don't fall within the exception, there are exemptions and waivers that exist in the original executive order that you could use to still enter the United States. Unfortunately, they're complicated. They're not really well described, the procedure for using them, but they still exist. Third, the people that are going to be hit the hardest are diversity visa or green card lottery winners. Most of them are not going to have ties to the U.S. or the bona fide job offer, employment offer, or connection with the U.S. entity that will permit them to be able to enter the U.S. on the visa. So they're going to be hit the hardest. Fourth, this suspension is for 90 days, so hopefully in 90 days things will clear up. But a basis of the executive order is that there be information sharing between countries to help solve any terrorism or security related issues. However, when you're dealing with some of these countries on the list, the idea that they would begin a partnership of sharing information in the U.S. is difficult to see at this point because of the political and global implications and relationships that currently exist. Hopefully there'll be some sort of resolution that could appease all parties and we could go back to the normal situation where people could travel. But for now, the 90 days is set, but after that it's unclear whether necessarily it'll be fixed. Fifth, for those who have non-immigrant visas, these are temporary visas coming to the United States. If you have a B visa, C1, a D, or I visa, you're going to have to show ties to the United States in some way that would allow you to come in. The rest of the visa categories for non-immigrant visas are okay. So for example, an E2 visa is not going to have this problem because there's a U.S. entity that's going to be working, employing the foreign person. Now, K1 visas were originally on that list of forbidden visa groups, but now State Department has permitted K1 fiancé visas to be allowed. With regards to immigrant visas, most categories are okay. So if you're doing EB5 investment, EB2 or 3 employment-based green card, you're going to be okay. Specifically, the EB1A category for extraordinary ability individuals is prevented if there's a self-petition, meaning a person is filing for their own immigrant visa green card, specifically are said to be prevented from being able to come to the U.S. unless they have other ties that allow them to come. Now, the EB2C national interest waiver is a peculiar situation. It's not listed in the State Department cable. This is a self-petition, so it kind of is similar to the EB1A extraordinary ability green card. However, the national interest waiver, as its name shows, is a special situation that may automatically be an exemption because it's in the national interest. So we'll just have to see how that plays out for people and how that goes. 7, as mentioned before, if you have a bona fide relationship with close family members, you could overcome the temporary Supreme Court restrictions. It's a weird list. Parents are included, siblings are included, half brothers and sisters are included. So if you have those kind of relatives, you could use those as a basis to come to the U.S. However, grandparents are included, cousins are included. So it's a peculiar list. You'd have to go look at to see if you fall within it. However, if you're asking for a tourist visa, the more family members you have in the U.S. actually could work against you because it could show a reason that you'd enter the U.S. and not leave the U.S. once your trip is over because of the fact that you have relatives here who have money, jobs, and potential opportunity for you to stay and not leave the U.S. So it's kind of a weird thing. The thing that's going to help you get the visa could also hold you back from getting the visa. Unfortunately, a lot of immigration laws and laws in general are contradictory in this way. Finally, with regards to business relationships, if there is a business entity or a university or a speaking gig that's causing you to come to the U.S., that is a reason for you to overcome the ban, at least for the next 90 days. However, you can't just make up a relationship or a business relationship or have a friend write a letter just to get around this ban. They specifically said you can't do that, so that's going to be researched a lot. So I think if you're going to have a situation like that, we have to show how it's a bona fide relationship, how the entity really needs the person to come to the U.S. and how they're an established entity as opposed to something new or made up. So that would prevent that person from coming to the U.S. I hope these tips help. There's a lot more to it. If you're planning on getting a visa to the U.S. and you're from one of these countries, or frankly from any country in the world, I always recommend contacting an immigration attorney to discuss your case to make sure there are no issues that could come up during that visa interview, or no issues are created now that could be a problem for a future immigrant visa, green card, or temporary visa. I wish you all the best.